Good day, Crime Talk aficionados. We have a great show for you today. First, the ex-sheriff, Mickey Stein, has a compelling defense, according to his defense attorney. Bryan Kohberger will have to wait for some appellate court to get some relief on the whole death penalty issue. Owning 170 guns is not illegal unless you're not a U.S. citizen. Two stories about people that are just not wired correctly. Neighbor disputes are the worst, ladies and gentlemen, and a Florida woman is going to prison for 25 years for wanting people to stay off her lawn. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications of when we go live or put up new content. And yes, you can always check us out anytime on any of your favorite podcasting apps. Now, before we get started, go to CrimeTalkSearch.com. All right? This is a background subscription service, and it is invaluable. Everyone should have this. All right? Now, listen, you're going to have people coming over for Thanksgiving, new friends, friends of friends, maybe people dating your children. You're going to want to check them out, all right? And when you go to CrimeTalkSearch.com and you sign up for that background subscription service, you're going to be able to do a background search on that person, and it will be completed while you wait, and then you will have a report emailed to you. And it's going to have all types of information, their contact information, possible address history, relatives, neighbors, associates, jobs, education, usernames, possible social media that they're linked to, assets owned, criminal history, bankruptcies, judgments, liens, and any other licenses that they may have or maybe got revoked. It's going to be everything that, well, they're probably not going to tell you as you're sitting there at the table asking to pass the cranberry sauce. No, you need to check them out. Information is knowledge. It's powerful, ladies and gentlemen. Go do a background search on that new person coming into your life. CrimeTalkSearch.com. All right, let's go ahead and open the record for November 26, 2024. Just, what is this? Christmas. This is Thanksgiving Eve, right? All right, let's get to it. Mickey Steins, ex-sheriff Mickey Steins. So during an arraignment on Monday at the same courthouse where District Judge Kevin Mullins was shot and killed back in September, a lawyer for the former sheriff accused of shooting the judge said that his client has a compelling defense. Well, there was a deposition his client gave in a separate federal lawsuit just days prior to the September shooting is part of that defense, said Mr. Stein's attorney. Now, at the hearing on Monday, a judge denied bond for ex-sheriff Sean Mickey Steins, who had worked for Mullins for years before the shooting in the judge's private chambers, meaning he'll remain in custody until a jury decides his fate. Now, Stein's attorneys entered into an initial plea of not guilty in circuit court and said they plan to file a motion for adversarial bond, and though everybody acknowledged that it will more than likely not be successful. Now, Steins was one of several parties sued in a federal court lawsuit back in 2020 over allegations that a guy by the name of Ben Fields, at the time, who was a Letcher County deputy sheriff, had exchanged favorable treatment to a woman on home arrest in exchange for sexual favors that just happened to take place inside Judge Mullins' private courthouse office. Apparently, there were no cameras there at the time. Even judges and sheriffs apparently can't be trusted, ladies and gentlemen. Anyway, Judge Steins is not accused of taking part in that exchange, but attorneys for the plaintiff have argued that he failed to properly train and supervise his deputy, who was convicted on state charges and spent several months in jail, while that federal civil case is still pending. Well, attorneys for the plaintiff in that case have said that they were a little surprised by the shooting and unsure whether it was connected to the Steins deposition, which lasted several hours. But the attorney for Mr. Steins said the timing of the deposition is certainly something that's going to be crucial in this case. He said, quote, "I do believe that this is a piece," end quote. This is a larger story. It's a story that in some way is difficult to tell. We look forward to sharing a more complete version of that as they go through the judicial process. Well, Kentucky's attorney Jackie Steele, declined to say whether he believed the deposition was a factor in the shooting or speculate on any other potential motives, but said he does not currently expect Steins to face any additional charges beyond the charge of murder of a public official. I think that's sufficient in and of itself. Anyway, one of the attorneys representing the plaintiffs in that civil case has said that he's still unsure whether the deposition is connected to the shooting in any way, and he said that he had people tell him it's directly related. Some people say it's completely unrelated, and some people say it's semi-related, so he doesn't know. Apparently, one of the attorney's co-counsels actually took the deposition, but added that the lawyer told him Steins had an odd demeanor during the several hours of deposition testimony. Well, retired Judge Julia H. Adams presided over the hearing on Monday after being appointed earlier this month to serve as a special judge at the arraignment. Now, she decided not to grant Steins bond after significant consideration, but the capital offense charge was a key factor in that. Yes, he faces the possibility of the death penalty if that's where this case is going. Well, I'm not sure the prosecutor would go the death penalty route in this particular case. It is one murder. He was a public servant for many, many years. Obviously, he blew all that away. And obviously, the aggravating factor is that he killed the judge. We can't have people going around killing judges. But it wasn't necessarily some sort of retaliation as far as we know, because he wasn't directly involved in any case with the judge. So the attorneys prosecuting the case, along with the Attorney General's office, said that after the hearing, it was too early to say whether they'll pursue the death penalty, and several of the special prosecutors recused themselves due to the familial relationship with the judge, hence the reason for the Attorney General coming in. Anyway, neither prosecutors nor Steins' defense team have provided a motive for the killing of the judge as of yet, and the hearing at the Whitesburg downtown courthouse lasted about 5 minutes. Stein attended in person along with his defense team and family members that were seated in the courtroom as well. Now, a grand jury indicted Steins on one count of murder of a public official last week, and this was the first news in the case since the preliminary hearing October 1st, where people in the courtroom were able to see the shooting that took place on September 19th. Now, Steins is the lone suspect in the case, and had initially entered a plea of not guilty back in September, days after his arrest and before he was sent to the district court, the circuit court there in Kentucky. Now, Judge Mullins has served as a district judge in Letcher County since 2009, and obviously was killed while sitting in his private office at the courthouse there in Whitesburg. Now, in the video shown last month, Steins can be seen firing at the judge multiple times in several volleys before leaving the room. Now, the sheriff, who resigned days later, was arrested at the scene and has been in custody ever since, and more recently being held at the Leslie County Detention Center. Now, no one else was injured and no one else was in the room during the shooting, although there were other courthouse employees just in the other part of the chambers, apparently, and as well as the courthouse. Now, the defense attorneys for Mr. Stein argued last month that the 24-second clip shown in court, viewed without audio, does not offer enough context, and additional footage should paint a much clearer picture of the situation. Now, he had not seen the entire video, even as of the preliminary hearing, but he expects to see the entire video soon. Now, at last month's hearing, a Kentucky State Police detective said just before the shooting, Steins called his daughter on his own phone, then used Mullins' phone to call her as well. The defense attorney has argued that the shooting occurred in the heat of the moment due to extreme emotional disturbance, and manslaughter, not murder, would be a more appropriate charge. Noted Monday that they do not concede this is a manslaughter case, and they plan to put on a full defense. Now, a lot of people are taking a look at this town of Whitesburg. Apparently has about 2,000 residents, and obviously there's been a lot of speculation as to why the shooting occurred. Now, when the district attorney recused himself due to his relationship with Mullins' family, he urged members of the community not to spread gossip and basically just have to wait for the truth to come out at trial. So he said, let the story be told in the courtroom. What's online, all these social media posts, everybody's opining about this case. It's a grain of salt. This is a complex case, but we believe there will be a complete defense for Mr. Steins, and we look forward to putting that on for him, his attorneys noted. Now, Letcher County is apparently in the far eastern Kentucky, of the Bluegrass State on the border of Virginia. And Stein served there as a sheriff since 2018 and had previously served as a bailiff in Mullins Court. They were friends, according to residents there in the city, and they ate lunch together just hours before the shooting. Now, a venue for the case has not yet been determined, which everybody's referring to as the elephant in the room. But Barkley wants the defense attorney for Mr. Steins wants the trial to take place in Letcher County. At some point, you can't find a corner of the Commonwealth of Kentucky that hasn't received some media exposure to this. We're standing a few feet from where this case should be tried, right here among Mickey Stein's peers. So Mickey Stein's attorneys must think they have the inside track if they keep it there in Whitesburg. I get it. I haven't seen all the discovery in the case. Like, no one has. It sounds like even the defense attorneys haven't seen anything. But if I was the defense attorney for Mr. Steins, I think I would shut up and just go try my case, save it for the courtroom, quit giving these tidbits that you may not be able to back up. All right? Heat of passion, it's going to have to be something pretty amazing that he just basically lost all of his faculties about him and just went and shot the judge. That's going to be a tough road to hoe, I think, in this particular case. Now, I would love to know all the details, but we're not going to speculate. Was there something nefarious going on with the judge? Was the sheriff doing something and the judge trying to help him? We don't really know. I've received emails from people, some saying the judge is a good guy, others saying Steins is a good guy. I don't know. All I know is what we've been allowed to see at the preliminary hearing and facts that have come out in the press. Hold judgment, ladies and gentlemen. Let's hold judgment on this. There's just too many facts. Now, obviously, if there is no heat of passion, this is just a clear first-degree murder case. All right? But you're going to have to give me something to say how this rises to the level of heat of passion, which obviously reduces the penalty. It's an affirmative defense saying, I did it, but I was somehow justified. But if the jury says you weren't justified, well, then you're guilty of first-degree murder of a judge that carries the death penalty. Next on the docket, Bryan Kohberger. That's right, Bryan Kohberger's lawyers lost the battle to keep the death penalty off the table in his trial, but their arguments could be used for the appellate courts, possibly all the way to the Supreme Court. Now, for those who are not familiar with the case, Bryan Kohberger is charged with 4 counts of first-degree murder and 1 count of felony burglary. He's accused of fatally stabbing University of Idaho students Madison Mogan, Kaylee Gonzalez, Zaina Kernodle, and Etha Chapin in an off-campus house back in November of 2022. Now, his attorneys tried to get the death penalty taken off the table, but Judge Stephen Hippler, well, he's going to allow the jury to decide whether Bryan Kohberger deserves a death penalty if he is convicted of the 4 murders and the burglary. Now, the motions that were made were pretty far-ranging and designed to be able to have the defense create federal appellate issues normally for any habeas relief down the road should Bryan Kohberger ultimately be convicted and ultimately be subjected to the death penalty. Now, the appeals process, we've talked about this before, for death penalty cases usually takes years, if not decades, to resolve because they start with the courts at the state level, then they move to the district court, and then they go to the appellate courts, in the appropriate circuit, and then ultimately to the Supreme Court. And sometimes they get kicked back and you start all over again through the process. So it is a long and arduous process indeed. Now, I told you none of those motions were going to win, but those were made for appellate purposes. And I mention that because I draw the distinction specifically as what you did not see in the cases of Lori Vallow or Chad Daybell in his Idaho death penalty cases. The fact that none of these type of motions were filed will more than likely be a basis in the Chad Daybell to say that his attorney was ineffective. Now, the Supreme Court has dipped its hand in death penalty cases on several occasions. Now, since the death of Ruth Bader Ginsburg and her replacement with Amy Coney Barrett in 2020, the court has stopped 2 executions and reversed a lower court to permit an execution 9 times. Now, last term, the Supreme Court ruled on nearly 30 death penalty stays of execution. The justices ruled unanimously in all but 3 cases, including the execution of Marcellus Williams. Now, while Bryan Kohberger's defense attorneys took a broad approach addressing various humanitarian and sociological issues surrounding the death penalty. The facts surrounding this trial are not very sympathetic to supporting the argument of essential unfairness, I guess you could say. It's all for appellate purposes. Anyway, the defense filed some 12 motions objecting to the death penalty, all of which the Judge Hippler denied. Now, the motions raised some various arguments, including the state's criteria for the death penalty, changing public opinion, and international law. Now, like I said, those motions are much more of a part of a much bigger appellate process to contest the government's case, and in doing so, reduces the chance the death penalty will be successfully obtained during any sentencing. It's all backup, okay? That's the problem with the death penalty case is, first you're trying to get it taken off the table. Then you're trying to focus on the facts of the case to present a defense. But normally when you got a death penalty case, for the most part, it's a pretty slam dunk case. And we'll see if the government's evidence can withstand the challenges that are brought forth by the defense in this particular case. We're going to have to wait and see. But like I said, the defense is planning on a conviction, hence the reason for all of these death penalty arguments. So anyway, like I said, these arguments and motions were not designed to impact the trial level. Everybody in that courtroom knew that they were going to be denied. It's just simply for the appellate issues. Hippler himself, the judge, reasoned in his ruling that the defense argued that the state's death penalty policy violates the International Covenant on Civil and Political Rights, apparently a treaty adopted by the United Nations and ratified by the U.S. The treaty requires nations to respect individual civil and political rights, including due process rights. And I know, because this is the hierarchy. You've got the Constitution, international law, and treaties, and then you got statutory, and it kind of goes in that order, ladies and gentlemen. And so, like I said, that's why they're making these arguments. And I draw your attention to the Chad Daybell case where none of these motions were filed in any way. Anyway, the court determined that those treaties only impact U.S. law if they are approved through conditional legislation or if they are self-executing, meaning they go into effect immediately upon ratification. So there you go, ladies and gentlemen. You can sign all sorts of treaties, but it doesn't become law unless it's ratified by Congress, the Senate, actually. So something to think about if you didn't know that. Anyway, all that stuff provides no basis for any relief, the court said, and in accordance with the weight and authority, the court finds it is not self-executing, has not been given effect by Congress, and provides defendant with no enforceable rights, the judge noted. Hippler's ruling was not surprising because of the binding precedent the court has to follow relating to the law in Idaho. Like I said, this is not a big surprise, and given both the United States Supreme Court and the Idaho Supreme Court have issued previous decisions addressing almost every issue raised by the defense team, it wasn't surprising how the court ruled. Now, the court order explains that the binding precedent forecloses almost all of the facial legal attacks on the death penalty in the Bryan Kohberger case. The court has very limited ability to review the prosecution's decision to file a notice of intent to seek the death penalty, and the only way to reverse the decision is to find the death penalty unconstitutional, which the judge was not willing to do. Anyway, that's what the defense was seeking. It didn't quite work out. So from here on out, both prosecutors and Kohberger's defense attorneys are going to focus on the evidence that's going to be admissible at trial. There'll probably be a lot more discovery motions. We saw just yesterday the judge kicked back a motion requesting a Franks hearing because the defense didn't articulate what they said was a false statement in the search warrants, and said, give me more specificity because I'm not going to go through 2,000 pages of attachments that you have sent to me. And so that's where things are going to come out. It's going to be a duel between now and the trial date as to what evidence comes in, what doesn't, negotiating back and forth. And I'm sure there's some talk probably on a weekly or maybe bi-weekly basis between the defense and the state to try and take the death penalty off the table. I am sure there has been a conversation with Kohberger and his attorneys to say, hey, if we plead guilty, we take the death penalty off the table. Would you give us authority to go talk and do that? I guarantee you those conversations have taken place. Now, do I have personal knowledge of that? No, but I have practiced law for 30 years, and I know those conversations are taking place. Now, if Bryan Kohberger is convicted and sentenced to death, all the evidence, orders from the judge, and any objections, those are all going to be brought up on appeal. So there you go, ladies and gentlemen. A little bit of analysis there as it relates to the Bryan Kohberger death penalty motions denied, just like I said they would be. It's all appellate stuff. It's all for the people, not the trial lawyers, appellate gurus that are going to try to do this. And a lot of the people that do death penalty work like that, this is what they eat, sleep, and breathe, and it is their mission to take the death penalty off the table. I don't see that necessarily happening anytime soon, particularly at the federal level. I'm a realist. I'm just a realist. There you go. And I think most states would have it. Here in the state of Colorado, we had the death penalty, and even from a defense attorney's perspective, it was a very good bargaining chip for the prosecution to say, hey, we're thinking about going death. And I'm telling you, when the DA tells you that, it changes lots of things. People's processes and how they think, it changes. And so, you have to, I think it was a shame for the legislature to vote on it to repeal the death penalty without putting it to a vote of the people here in the state, because it is a bargaining tool, just another arrow that the prosecutors had at their quiver to resolve cases short of trial. Let me know what you think. I know it's a hot issue. Some people all for death penalty, other people are against it. I think it's legal. I think it's, the states can decide what they want to do, but the United States Supreme Court has determined that it is not unconstitutional. It is not cruel and unusual punishment, and therefore, as long as due process is given, and in every death penalty case, you get super due process. Next on the docket, it's not illegal to have 170 guns, ladies and gentlemen, but you need to be a citizen to do that. Yes, that's right. A federal judge denied a motion to dismiss a gun charge against an Ohio man who was illegally in the United States for almost 2 decades. So Carlos Serrano Respeto was charged in early 24 and later indicted for possession of firearms by an alien unlawfully in the United States. That's a crime. Handled several of those cases over the years. Anyway, the Bureau of Alcohol, Tobacco, Firearms, and Explosives investigated Mr. Serrano and conducted surveillance after he completed a purchase for at least 22 firearms. He claims he was a U.S. citizen on the firearms form. Oh, the form, the dreaded form. Anyway, after a search of his home, agencies seized approximately 170 guns, tens of thousands of rounds and ammunition, a smoke marine markers, and at least one firearm, a .50 caliber Barrett rifle. Gosh, Mr. Serrano, you should have called me. Everybody needs a Barrett .50 caliber rifle. I would love to. That's what's on my list for Santa this year. .50 caliber Barrett. All right. If you know of any, no, it's got to go. It's got to be all legal. Got to go through a federal firearms dealer, but you can get them. You can buy them directly from Barrett, and they'll ship it to a store. But anyway, Mr. Serrano, we move on. Anyway, Mr. Serrano said some of the weapons were for self-defense. Photos showed he kept the firearms in gun safes and handguns mounted in holsters on the wall of his closet. So he sounds like a responsible gun owner. Anyway, after the gun charge, his lawyer submitted a motion to dismiss, claiming Mr. Serrano has the right to bear arms under the Second Amendment. He moved to Ohio in 2022, where he previously lived in Arizona. He told the court that he last entered the country without authorization back in 2008. He also apparently owns a business that remediates fire and flooding damage. And then on November 21st, 2024, the federal judge denied the motion to dismiss the charge, saying disarming unlawful immigrants like Mr. Serrano, who have not sworn allegiance to the United States, comports with the nation's history and traditions of firearm regulation. The swearing of an oath of allegiance occurs through the naturalization process, not through his asylum application or his years of living in the United States. With the motion denied, the case is currently set for trial to begin on January 21st, 2025. Now, I would believe that this case is being set up to go to trial. I would anticipate Mr. Serrano will go to trial and he will appeal this because as it sits right now, Mr. Serrano, now he has an asylum claim, so even if he gets convicted and goes to prison, he may not be deported. But the question then becomes, is he entitled to the right to possess and bear arms as a non-citizen? Now, there was a case that was decided, I think, last year or the year before last, and I forget the name. I should have prepared better. I apologize. where a man was here in the United States. His visa had expired, and he went to a gun range and was holding a gun. He was charged, but the Supreme Court said you have to be able to prove that he knew that he shouldn't have possessed a firearm. That may be a defense that Mr. Serrano takes as well. Interesting issue. Just saying, ladies and gentlemen, add to your Christmas list one Barrett 50 cal for Scott at CrimeTalk. It can be sent to the office. Anyway, we move on. Next, got a couple of stories of people that are just not wired right. Okay, this guy, he's an escape artist. Well, after he killed a kid. So a very unusual series of events unfolded Friday after a man pled guilty to first-degree murder in the 2018 death of a 13-year-old girl by the name of Hania Aguilar. Now, Michael Ray McClellan admitted to kidnapping Aguilar from her driveway and then killed her and disposed of her body. Now, he was sentenced to life in prison without the possibility of parole. He deserves. He pled guilty. He's no longer given the presumption of innocence. He also pled guilty to charges of attacks on two other unrelated victims, which occurred in October of 2016 and July of 2018. But here's where it gets interesting. McClellan tried twice to escape from the correctional officers, both before and after the hearing. So the prosecutor was quoted as saying, "I was in the courtroom when he pled guilty, and he gave a little statement to the family and everything, but now I see all of that was just for show." He had an escape plan in his mind the entire time, the district attorney said. Anyway, the prosecutor said he wasn't exactly surprised this happened and was thankful to the deputies who took swift action with this very dangerous person. Now, the sheriff said that Mr. McClellan first tried to break free while being driven to the court using a makeshift handcuff key, and then the deputies were able to put a stop to that because they apparently had to stop on Interstate 40. But on the way back to the detention facility, McClellan hit a latch on one of the deputies' gun holsters, and the weapon was released. That's right. Mr. McClellan at one point actually had possession of the officer's firearm. Now, apparently, the deputy driving slammed on the brakes and was able to get the gun out of the hand of Mr. McClellan. Thank goodness that didn't end very ugly. Anyway, a little fight took place apparently right there for the gun with the passenger and the detention officer. The defendant was sprayed with some pepper spray. He immediately released the gun and limped back to the seat and said, "You got me, you got me." Anyway, Mr. McClellan is being held at the high security area there in North Carolina, a prison in Raleigh, North Carolina. But how did this all get started? Well, apparently back on November 5th of 2018, Aguilar was abducted outside her Lumberton home. A man wearing a black and yellow bandana forced her into a stolen SUV while she was warming up her family's car to go to school. Her body was discovered weeks later at the bottom of a shallow pond about 10 miles from where she was abducted. And about 10 days later, the FBI and the Lumberton Police Department arrested McClellan, who was already in custody for charges relating to a different case in connection to her kidnapping. And it was revealed investigators had McClellan's DNA and the rape kit from 2016 before Aguilar's was actually kidnapped. Now, obviously, we hope Hania's family and the McClellans and other victims are somewhat comforted knowing that Mr. McClellan is going to spend the rest of his life in prison for the vicious attack. Obviously, that's assuming he doesn't escape. Come on, guys. Sheriffs, the guy's tried twice. He's failed twice. He's only got to be right once. You guys got to be right 100% of the time. Be careful out there. That guy's just not wired right. Seriously, just not wired right. Anyway, another guy. So a subway goer was slugged in the face in New York by an irate seatmate on a Manhattan-bound subway, but he managed to wrestle, quote, the little bitch to the floor, end quote. But that's when fellow passengers jumped in to help his attacker. Anyway, so Alexander Ratkin was riding the N train to his Manhattan finance job Monday morning when he sat down next to Timothy Barbie. As the train took off, the car jolted, causing Ratkin's knee to bump Mr. Barbie. That's when Mr. Barbie apparently got very aggressive. Mr. Ratkin was like, "Hey, dude, just chill. It's like 8:30 in the morning. Like, who needs this stuff? Just chill." Anyway, that apparently set Mr. Barbie off because apparently, like I said, Ratkin's knee touched Barbie's knee, and that triggered him. Now then, there was footage taken of the passengers captured the two staring at each other down before Barbie yelled, "It's effing done. Stop staring at me," and proceeded to tell the protesting Rakin to make me chill and to, quote, shut the F up. Anyway, their verbal exchange apparently quieted for a moment when they continued to stare at each other. And then Barbie said, "I ain't got time to go to jail today." Well, apparently he did, because then he smacked Rakin across the face, sending Mr. Rakin's glasses flying, and then the camera cut out. Anyway, Mr. Rakin was able to wrestle him to the ground, just kind of hold him there, and that's the crazy part started, is that they were literally upsetting, like, "I'm actually emotional about it," he said, and people on the train were trying to help him. Like, that was the most insane thing Mr. Rakin thought about the whole incident. Anyway, it was very interesting, apparently, to the onlookers, but Mr. Rakin said that he turned into a little bitch right away. He was like, I can't breathe. Please let me go. Please let me grow. Please let me go. Anyway, somebody said, give him some water. I can't breathe. And they started giving him water, and that's why he thought it was a little insane. Anyway, Barbie turned into a little bitch, even though he's the one that hit Mr. Rakin in the face. Anyway, everybody was telling, hey, just let him go. Obviously thinking of the Daniel Penny case, you don't want to get charged with murder, even though the other guy started it. Anyway, Rakin continued to pin Barbie down until the train pulled into the next station. Once arrived, the police showed up, and they hauled away Mr. Barbie, the initial aggressor. They apparently asked Mr. Rakin if they wanted to press charges, and he said, yeah, why not? This person, he can't just walk around punching people. Anyway, Barbie, apparently a Brooklyn native, has no prior arrests. He was charged with third-degree assault. Rakin had some lacerations and some scratches on his face, but he declined medical attention. He said the attack should not come as a surprise to anyone. He's like, everybody sees what the way the city is right now. It's like changing. I already saw the city like this, that you're in a constant danger of aggression or violent crime, he said. It's not like it's changing. It's just kind of reaffirming that that's the way the city is. Listen, I've been to New York many, many times. I love it. Riding the subway in New York, yeah, I will pass these days. Never been a big fan of subways anywhere, maybe London or something. DC's not bad, I guess. Yeah, New York, until New York gets their act together and wants to start enforcing the laws and putting the bad guys away, CrimeTalk won't be coming to spend their money there. Now, I know the Daniel Penny case ended last week. We're taking a week off. Then we're going to do closing arguments. I'm a little surprised the judge didn't just roll into closing arguments today, let the jury deliberate, unless there must have been jurors that had travel plans. Who knows? But, Daniel Penny case, this raking guy, gosh, be careful out there. Hashtag Daniel Penny, not guilty. Neighbor disputes are the worst, ladies and gentlemen. Neighbor disputes are the worst, ladies and gentlemen. We've all got that neighbor. It's probably me these days. Get off my lawn. No, I'm not like that. I've mellowed. Although I used to have kids playing in my, yard when I was in law school. It used to bug me out because I really had a nice lawn. And like, why are those kids out there playing on my lawn? They're going to mess something up. Then I got to know the family and the kids, and it was fine. But when they left their stuff in my yard, I would put it in the garage, and then they would have to come ask me to get their stuff back. I know, it was petty. I've matured. I've matured, ladies and gentlemen. But anyway, what I have figured out over the years is that neighbor disputes are the worst, okay? And that's why a woman is going to prison for the next several decades. So a Florida woman who just happens to be white, who gunned down her black neighbor and was a mother of 4 kids over a long-running dispute about the children playing outside her home, was sentenced to 25 years in prison. Susan Lawrence, who's 60, ladies and gentlemen, she's going to die in prison, claims she was acting in self-defense when she shot and killed her neighbor, Ajike A.J. Owens. Judge and the all-white jury there in Ocala, Florida, they said found her guilty, didn't buy her excuse of self-defense. The judge said that the shooting was completely unnecessary, and the shooting, the judge found, was based more on anger than fear. Now, Lawrence was convicted of manslaughter in August for the shooting death of Owens after she shot the single mother through the front door on June 2nd of 2023. The two had argued for years over Owens' kids playing in a grassy area near both of their homes, and on the day of the shooting, Owens was yelling and banging on Lorenz's door after her children said the woman chucked an umbrella and roller skated at them, which Miss Lorenz denied. Anyway, after Lorenz shot Owens through the door, once with her .38 caliber handgun, she told police she feared for her life, but jurors disagreed as the evidence that there were at least a 3-year dispute between the neighbors that was presented at trial. Neighbors said they overheard Lorenz say nasty things to the children and that she was always angry that those kids were playing on the field near her home. Now, a jury took less than 3 hours to convict Miss Lorenz, and like I said, she faced a maximum of 30 years behind bars, but the judge gave her some leniency of 25 years, taking into account her age, and apparently she has some mental health issues and suffered some abuse as a child. Now, Miss Lorenz apologized to the Owens family in a statement to the judge, but she stuck by her self-defense stance, saying she was literally terrified of the mom. She said, "I wish I could go back and change things, but I never intended to kill anyone," she said. Don't shoot through doors, ladies and gentlemen. General rule of thumb, let them break the plane of the house. Now, check with laws in your local area. This is not legal advice, but generally under the castle doctrine or make your day type of defense, once they break that plane of your house, you can fire away. Not a moment sooner. No, you can't shoot them outside and drag them inside. I know you were all thinking that. You can't do that, ladies and gentlemen. Next, on this day in legal history, on November 26th, 1621, a jury trial took place in Virginia, setting a precedent for the legal system in the American colonies. There you have it, ladies and gentlemen. Where else were you going to learn the first jury trial took place on November 26, 1621, other than here in Crime Talk? We're making the world smarter, ladies and gentlemen. Next, on November 26, 1789, Congress forwarded the first 10 amendments, known as the Bill of Rights, to the states for ratification. Think about that, ladies and gentlemen. The Bill of Rights, the first 10 amendments, Constitution, this country never would have been founded but for the colonists saying, nope, we're not going to ratify the Constitution unless the Bill of Rights are there, which are limits on the government, ladies and gentlemen. Limits, limits, limits. Those founding fathers did not trust people in power, dealt with dictators and despots and kings. Go through those first 10 amendments. I'm telling you, those are a checklist for a dictator. What do dictators do? Take away all what would be described in the First Amendment. Second, take away the guns. Third, not really applicable so much anymore, but they used to make you take care of the, British troops. Feed them, take care of their animals. That was a big deal. It was number 3. Fourth Amendment, unlawful searches and seizures. Fifth Amendment, right to due process. Can't take your property. Can't search your property. Due process, big deal, right? Sixth Amendment, right to counsel. Seventh Amendment, right to jury trial for civil matters. Eighth Amendment, cruel and unusual punishment. Sixth Amendment, also right to a counsel. Ninth Amendment, not really applicable so much. And the 10th Amendment, hey, not anything not specifically mentioned in the Constitution for the powers of the federal government are reserved to the states. They refer to that as the dormant 10th Amendment. It's coming back, ladies and gentlemen. Think about it. Go back and read your Constitution, and it'll show you these are the various things that the federal government must do, right? Defense, trade, interstate commerce, immigration. Yep, that's about it. That's about it. Everything else is reserved to the states. Think about it. I blame. I'll say it again. FDR threatened to stack the courts. The judges let in all of this bloated government size. None of this stuff was ever intended to be in the Constitution, ladies and gentlemen. And if it was supposed to be, well, there's a way to change the Constitution. Anyway, we digress. Let's jump to 1977 on this date, November 26, 1977. David Berkowitz, a.k.a. the son of Sam Killer, pled guilty to a series of murders in New York City. And on November 26, 1975, Charles Manson's follower, Lynette Squeaky Fromm, was found guilty by a federal jury in Sacramento, California, of the attempted assassination of President Gerald R. Ford. Making you smarter every day, ladies and gentlemen. And finally, our dumb criminal of the day. Just when we think we're getting smarter, we dumb it down a little bit with our dumb criminal of the day. And not that you all are dumb. You all are brilliant. You are Crime Talk aficionados. You know what you're talking about. I think we get a little dumber every time we hear of a dumb criminal of the day just because what they do is so stupid. All right. Nobody hates commercial air travel more than I do. And I don't want to sound like a snob. I'm just telling you, I hate it. I hate it. I hate it. But I've never been this frustrated as take a look at this guy. This is a United Airlines passenger, and he had to be restrained by his fellow flyers after he began assaulting the chair. Now, this flight occurred on November 16th on United Airlines Flight 502 from Austin to Los Angeles. And apparently a fellow passenger who filmed the incident claimed that he awoke to see this unidentified passenger kicking the seat just about an hour from touching down at LAX. Initially, apparently nobody tried to intervene. The flight attendant actually walked by and no one was doing anything. But apparently at some point, someone finally decided to stop this attack of the seat. So two other passengers then zip-tied the miscreant and his hands and feet and seat belted him in his seat so he could stop attacking the seat. Needless to say, upon landing at LAX, the unidentified seat attacker was met by police. He was immediately banned from all future United flights. And anyway, the rest was a happy ending. Austin to LA, was that hour and a half flight at most? Really? And you had to start attacking the seat? Nobody knows exactly why the unidentified man tried attacking the seat. Some people speculate that maybe there was a crying baby behind him. I don't know. Maybe someone told him to, could you please put your seat up forward? It looks like it's a little farther back in the plane, not as much leg room. Just another reason to hate commercial air travel. All right, I'm 6'3". I need my leg room. All right? Hate commercial air travel. Hate it, hate it, hate it. And then you have to deal with crap like this. All right, that's all we have for today, ladies and gentlemen. Have a wonderful day. We'll see you next time on Crime Talk. And remember, the Constitution matters.